So we have an important update in the legal battle that could bring down the NFA and its restrictions on suppressors. The DOJ has officially filed its response to the Fifth Circuit Court of Appeals regarding a high-stakes petition for a rehearing en banc. The government is scrambling to defend the NFA's registration and taxation scheme after being backed into a corner by a panel of judges. If you've been following this channel, you know that this case started when the Fifth Circuit panel made history by ruling that suppressors are in fact arms protected by the Second Amendment. But because of an older circuit precedent, the panel was trapped into upholding the conviction anyway. That led two conservative judges to write a critical concurrence on that ruling, telling the defendant that he needed to seek en banc review to wipe out that precedent in the Fifth Circuit. The Fifth Circuit gave the DOJ a strict, non-extendable deadline to respond to this case, and that response is now in. Today, we are going to be diving deep into the full backstory of this case. We're going to be breaking down the DOJ's desperate filing, trying to defend the NFA and its suppression restrictions, and we're going to talk about why now the NFA is on thin ice, and how a case like this is likely heading to the Supreme Court because of the circuit split that's developed on suppressors and whether they are in fact protected arms. Now, before we jump into this video, if you like this type of content and you want to make sure you get it going forward, make sure to subscribe to the channel. Also turn on the notification icon to never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always expanding upon their benefits to try to give you as much as possible as a member. So if you're interested, you can check them out using the links down below. And right now, if you decide to sign up using my code ARMSCHOLAR, you can get $50 off of the individual sign-up fee or $25 off the family sign-up fee. Now, to understand how critical and huge this case actually is, we have to look back at a prior case in the prior precedent that was set by a court in revolving around suppressors and whether or not the NFA is constitutional. So this really all stems from the case US versus Peterson, a major suppressor challenge that we have covered here on the channel. In that case, law enforcement raided Mr. Peterson's home, found an unregistered solvent trap, treated it as a suppressor, and the DOJ hit him with a standalone NFA violation, and essentially with that carried a 24-month prison sentence, which Mr. Peterson is currently serving. Now, in that case, the Fifth Circuit did something incredibly dangerous. They claimed that the NFA is presumptively lawful because it operates like a shall-issue licensing system. Essentially, that panel's ruling established this rule, saying that as long as the government has an objective process to register and tax you, the restriction can in fact survive. Now, Mr. Peterson appealed to the Supreme Court, but the Supreme Court refused to step in at that time. Because of that inaction by the Supreme Court, Mr. Peterson's final request for house arrest was actually denied, and currently he is serving time in federal prison. So that brings us directly to this case and the new findings in this case, US versus Comeau. Now, Mr. Comeau was prosecuted under the exact same federal statute for possessing an unregistered suppressor. He argued that the NFA violated his constitutional rights, but the district court flatly rejected those claims. And essentially, they found that silencers are dangerous and unusual weapons, not protected by the Second Amendment. Now, at that time, Mr. Comeau then appealed up to the Fifth Circuit to a 3-judge panel, and this new panel just did something kind of unprecedented. The court explicitly ruled that suppressors absolutely are in fact protected by the Second Amendment. They found that they are protected arms. So writing for the court, Judge Jerry Smith dismantled the government's current arguments. The court recognized that suppressors reduce loudness, lower the risk of hearing loss, eliminate muzzle blasts, and also can increase accuracy. The court ruled that these are critical functions that make a firearm safer and more effective for the core lawful purpose of self-defense. Now, under Bruin, an item does not have to be strictly necessary for a firearm to function. Instead, it just has to facilitate armed self-defense. So this is a massive constitutional win, and we got a critical ruling here where the Fifth Circuit said suppressors are in fact protected arms. The Fifth Circuit officially cemented that into the law, and that also created a very direct circuit split on this very issue, since the Ninth Circuit recently also ruled, and in their view, suppressors are not protected arms. That creates a circuit split, which no doubt eventually will tee up a petition for the Supreme Court to review this issue. Now, you may be asking yourself, well, if suppressors were found to be protected arms in this case, why was Mr. Comeau's conviction still affirmed? Well, this is where the frustrating reality of the judicial system and precedent currently kicks in. Under a legal doctrine known as the rule of orderliness, a 3-judge panel of an appellate court is completely bound by the decisions of a prior panel in that same circuit. Because the previous panel in the Peterson case manufactured a rule saying that the NFA's registration scheme is presumptively lawful unless you can prove exorbitant fees or lengthy wait times, the new panel's hands were actually legally tied. But this is where the story starts to take a very critical turn and really where it backed the ATF into a corner. Circuit Judge Edith Brown Clement was joined by Judge Stuart Kyle Duncan, and they issued a fiery concurrence. And in that opinion, they aimed it directly at going back against that Peterson precedent and doing away with it. They wrote very clearly and they stated bluntly that Peterson was a massive mistake that needs to be revisited and overturned by the full en banc panel court in the Fifth Circuit. In that statement, she pointed out that the Peterson case took a random, modest footnote from the Supreme Court's Bruin ruling and twisted it into a binding legal doctrine, which it never was intended to actually be. Mr. Comeau's legal team did not waste a single second after seeing those filings from the court saying that they should in fact seek full en banc panel review. And so very quickly, his counsel sought full en banc panel review in the Fifth Circuit. The second that the petition actually hit the docket, the court automatically canceled the mandate that was issued against him by the lower court. They froze the case in place, and now they're taking a serious look at this issue. Now the government's formal response has actually been filed, and the DOJ is pulling out every stop to prevent the full court from hearing this case and ruling against them. So here are the main arguments that the DOJ is now presenting for why the full en banc panel of court in the Fifth Circuit should deny review to this case. Their first argument surrounds footnote 9, and they say that this footnote in Bruin protects shall issue regimes, and they say that the NFA operates like a shall issue regime. The DOJ argues that Peterson was correct and that licensing and registration schemes do not implicate the Second Amendment unless a defendant proves administrative abuse. Now, the problem with that and the problem with footnote 9 in Bruin is that it's being applied too broadly and far beyond the public carry licensing and CCW licensing that it was actually referencing in that decision. Also, it was dicta, and it was really not supposed to be expanded to all types of licensing schemes or anything like that, but here the DOJ wants to expand it further. Now, second, the government argues that even under a full Bruin historical analysis, 19th century state statutes imposing taxes on dangerous weapons serve as historical analogs for taxing and registering suppressors. Now, the third argument really goes down to processing times and the $0 tax. The DOJ is actually actively arguing that the system isn't abusive because e-form wait times have dropped to roughly 6 days, and recent legislation reduced the NFA tax to $0. Now, here's the problem with this. Essentially, the opposing side is saying just because something is fast and because it doesn't cost a lot of money does not make it constitutional. Something that is fast and doesn't cost a lot of money can still violate your Second Amendment rights. And so to just simply say because we give these tax stamps really fast and for $0 does not mean that it's not violating the Second Amendment. So what does this mean moving forward in this case? Well, it means that the battle over the NFA has officially accelerated because 2 influential judges have already written a literal roadmap detailing exactly why the current circuit law here in the Fifth Circuit is unconstitutional and needs to be done away with. They called for the full Fifth Circuit en banc panel to take up this case and to review and reverse this precedent, and it seems like that is the way that the Fifth Circuit is moving. They can permanently dismantle that Peterson ruling, and if they strike it down, the federal government will finally be forced to actually face a true Bruin 2-step analysis, trying to justify the NFA and these suppressor restrictions. Also, a full court rehearing and positive ruling would no doubt help Mr. Peterson, who's currently sitting in prison because of that incorrect ruling in his case. So let me know what you think down below. Do you think the full Fifth Circuit is going to take up this case, reverse and wipe out that Peterson ruling? Or are they going to deny this? And eventually, do you think the Supreme Court's going to take this up because we have a circuit split on whether or not suppressors are protected arms? Let me know your thoughts down below in the comment section. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.